Recording in progress.
Sì, vado io direttamente. Ok. Buongiorno. Buongiorno.
Good morning. On behalf of the honorary rector, who cannot attend today's event due to institutional engagements, which he could not defer, the Department of Law of the University of Campania, of which I'm the proud director, I would like to welcome all of you and thank you for your presence. Today's international conference celebrates the conclusion of SELECT project, which the Department of Law was lead partner. And thanks to the efforts by Mrs. Eugenia Bartolone, who is a full professor of EU law and also the professor of law at our department. And she worked as project leader for this initiative. So I would like to congratulate Eugenia for today's initiative and for the flawless organizations of this event. So these activities are funded by the EU and target transnational training of lay judges and honorary judges of a number of EU countries, including Italy, Austria, Belgium, and it focuses on the correct application of the European Charter of Fundamental Rights, with the objective to raise awareness among those who work in the European judicial sphere, and this way to implement a coherent and effective application of EU law, but also to strengthen awareness among these counterparts of the added value attached to the Charter. Today's final event, which will be attended by all partners, is an opportunity to discuss with leading international scholars on about the scope and the effectiveness of the Charter, and also in light of case law which has shaped the actual contents of the Charter in practice. And also it is an opportunity to check the outcomes of, and to take stock of the outcomes of the SELECT project. So after the introduction speech by Mrs. Bartolone and Mrs. Tanzarella, who is an associate professor of constitutional law at the University of Milan Bicocca, we will be discussing today's topic during a session chaired by Antonia Tizzano, who is a former vice president of the Court of Justice of the European Union and also an emeritus professor of EU law at the University of Rome, La Sapienza. And there will be contributions by Professor Roberto Bin, who is full professor of constitutional law at the University of Ferrara, and also Professor Enzo Canizzaro, who is a full professor of international law at the University of Rome, La Sapienza, and also by Mr. Joseph Whaler, who is full professor of public law at the New York University School of Law. And this session will will wrap up with an intervention by Mrs. Marta Cardabia, who is a full professor of constitutional law at the University of Milan Bocconi. So, high-profile rapporteurs, I would like to thank all of you for the very insightful presentation that I'm sure you will give us and which will enrich today's event. Lastly, I would like to also thank Professor Bartolone and all those who have contributed so passionately to the success of this very important initiative. Thank you. Thank you, Director, for giving the regards of our department to the participants. So, an introductory speech is always a challenging task. I will approach this in the way that I'm most familiar with. First of all, I would like to thank all of those, and there's many of you, who made this initiative possible, this final conference possible. Today's initiative is something I care a lot about for two reasons. First of all, because today's event is the final event of a EU project, select project, of which I have been the coordinator and which we have been working on for more than 2 years. It focuses on the Charter of Fundamental Rights, but it also aims at training honorary and lay judges. We have come up with a manual which has been drafted in many languages, and this was the result of a broad transnational partnership, which the director was recalling earlier. 5 member states have participated in this, and it has been a successful project, as the figures show, but also as shown by a consistent interest that has accompanied this initiative throughout its various stages. The second reason is that this project allowed me to bring together so many teachers, and I would like to thank all of these teachers. I'm feeling a bit emotional here, but all of them have contributed and are still contributing to studying an instrument, which is the Charter, which is crucial, and it's also challenging. It is not by chance that when we talk about the Charter, we are talking about open questions, unresolved dilemmas. And I'm saying this in light of the title of the presentations that we'll be hearing today, and hopefully we can actually project the agenda on the screen here. So, looking at the titles of the presentations, I understand that talking about the Charter is to open a debate on something which, a topic which is still unresolved, and that is the coexistence of several systems that protect fundamental rights, and more specifically, how to determine the legal consequences of the Charter within national legal systems. Because we have a very challenging legacy to deal with, and this raises a number of questions, such as how to identify a balanced relationship between EU legal system and national legal systems. So this is all the more relevant if you consider that the Charter seems to somehow lower the protection standards that are guaranteed by national systems. And referring to Article 51, paragraph 1 and 53, and I think that these are not helpful to solve the dilemma. And the reason is that they are based on a mutual exclusivity model between the various fundamental right protection systems, and therefore they are not fit to ensure the implementation of a system that can safeguard fundamental rights as best as possible. So Article 51, paragraph 1 says that the scope of the Charter is the same as the scope of the European law. Well, it is true that the Charter is mandatory for member states when implementing the EU law, but it is also true that the notion of implementation has been so broadly interpreted, that it includes, besides specific legislation, implementing legislation, for example, it also includes the various national laws, which for many reasons are related to the EU law and can also interfere with the EU law. And therefore, they step into the scope of application of the EU law. So if that is true, so you are talking about clashing, sometimes potentially clashing systems. So because of the broad scope of application of the EU law. So this means that national laws will not be protecting the fundamental rights as guaranteed by the national constitution every time that it can be encompassed within the EU law. So this means that there is a very limited scope in this way for national laws to not be compliant with the Charter and with the scope of the Charter and of EU law. So national laws must be subject to the EU law. So this kind of conclusion, which can be discouraging, but I think this is made perhaps even worse by the implementation of Article 53, according to which the broader protection of the rights, and it means that the application of the Charter does not prejudice the application of other instruments that can ensure broader protection. So, by applying this criterion, the fundamental rights safeguarded by the Constitution might apply instead of the Charter within the European Union. And so if that is true, Article 53 and the broad protection criterion included in Article 53 might actually solve the dilemma between between clashing legal systems by ensuring that the system which provides the broader protection shall prevail. But it is not the case, because Article 53 is somehow ambiguous because it applies within the scope of each protection instrument. So this means that it essentially applies for conflicts between legal systems, not within individual systems. So if that is true, this criterion has a very limited scope, and therefore it is not fit at all to solve conflicts between systems, between legal systems. So, but even if Article 53 were applicable, what kind of conclusion could we draw? What would its application entail? Well, Article 53, the broader protection criterion, would in the long term break down the parameter of validity of national law and diminish its degree of protection, create some fragmentation. And that is something that we cannot tolerate. It is not by chance that the European Court of Justice stated that one interpretation of Article 53, which authorized the member states to use their fundamental rights instead of the Charter, if those fundamental rights ensure a higher standard, including within the scope of application of the EU, well, that interpretation is not admissible because it would impair the principle of the primacy of EU law. So I've made a lot of points here, but in this, from this point of view, I don't think it is unjustified to conclude that it is indeed hard to identify a balanced set of interests, because the models on, upon which they are, the individual systems are inspired is an exclusive, a mutually exclusive model. So, in the words of the court, in the Franson judgment, there are no situations that fall within the EU law in which the Charter does not apply. So that is something that cannot be questioned. However, there is a but here, there is a however here. And it seems to me that for some years within the Court of Justice, we have seen some willingness to modify the exclusivity model, and which would enable fundamental rights as guaranteed by individual constitutions to somehow enter the legal scope that is reserved to the Charter. So again, in the words of the court, but reversing those, there might be situations which fall within the scope of the EU law without necessarily being obliged to apply the Charter. So what is the crucial element to understand when there is a diminishing of a diminished application of the Charter? Well, the principle here is the degree of harmonization and how high that degree is in a given sector versus the national law. So I'm sorry if I'm getting a bit too technical here, but I think, in other words, that the Charter the fundamental rights safeguarded by Constitution would overlap with the scope of the Charter in a manner which is inversely proportionate to the degree of completeness of the European law that is affected by the national law. So there must be a scale on this, and we have the two extremes of the scale. So one is full application of the Charter with regard to a law that can fall within the application of the European law. And on the other end of the spectrum, we have the other hypothesis, that is the implementation of fundamental rights protected by constitutions with respect to a national law that is, of course, part of the EU law, but belongs to an unregulated sector. So in order to the Charter application to be triggered, it is not enough that a law falls within the scope of the European Union, but we also need to check whether or not that individual national law is sufficiently complete. So, and I think this is something that the court has confirmed itself, not only in 𝗪𝗏 2, but has repeatedly made reference to harmonization criteria in several judgments, which even indirectly refer to the degree of harmonization. We're talking about judgments which predate 𝗪𝗏 2, the 𝗪𝗏 2 judgment. I recently came across a very interesting judgment which was issued on March 2022, in which the court refers to the harmonization element to exclude the applicability of constitutional of fundamental rights as guaranteed by individual constitutions. So I'm about to wrap it up, but I'm sorry if I was a bit too long, but the takeaway here is that we might be pessimistic, but there seems to be some some gleam of hope here in terms of striking the right balance between national legal system and EU legal system. And in order to strike that balance in terms of fundamental rights, I think that that's all from me, and I would like to thank you. And before I give the floor to Professor Pizzano, I'll give the floor to Mina Tanzarella, to Professor Mina Tanzarella, who is the national focal point of the Charter of Fundamental Rights at the EU. Thanks again for being here today. Thank you very much, and for inviting me, Professor Bortoloni. And I hope I will not get too nervous today, because of course I'm here attending this event with lots of high-profile scholars. So I will not be too long. I'm here today as focal point, a national focal point for the EU on the EU Charter of Fundamental Rights. And I was appointed focal point recently, so my responsibilities are still being defined, but we are working with other national focal points on our approach. And the focal points were introduced and were actually requested by the European Commission as part of its 2020 strategy on reinforcing the application of the Charter of Fundamental Rights, in which the European Commission encourages member states to promote mutual understanding by mutual learning by sharing the information on the use and application of the Charter at local level. So we are still defining the various responsibilities of my role, because there are still many unresolved sides and issues concerning the Charter. We will be devoting today's event entirely on to analyzing several topics which are very relevant to this, at least judging from the titles of the various presentations. So in terms of creating a role which at a national level can disseminate the knowledge of the Charter, if we look at this from a pessimistic point of view, well, it can be challenging. Well, what I mean by that is that the issue of how we apply the European Charter of Fundamental Rights in terms of spreading its knowledge horizontally, that means across officials and the civil society in general, might bring about the risk of making individual states complacent in terms of accepting a degree of protection which has been defined elsewhere, and specifically at EU level. All the more so if we are talking about cases in which the individuals are calling more and more for fundamental rights. So the idea that you have a charter that is directly enforceable, directly applicable, because it is claimed at an individual level, including through lawyers, and therefore becomes a criterion that can be relied on before a judge. And the judges themselves can refer to consolidated and established European Court of Justice case law, especially when it comes to the prohibition of discrimination, which was crucial in terms of analyzing the horizontal effects of the Charter. So the risk here is that we forget about the United in Diversity motto, which is the assumption, which was the assumption for Europe to also take care of fundamental rights. So if we forego that principle, then we face a risk. But risks, as usual, must become opportunities. It is one thing to train and disseminate the contents of the Charter in a neutral way. And it is quite another thing to analyze the bottlenecks and make sure that there is some interdependence, not only between the professionals of the legal system, but also there is a bottom-up approach. And that can become an added value. And the Constitutional Court has shown that this can be the case. And I recently saw an interview by Francesco Vigano, who said that the court wants to be a part of this interaction and in order to avoid that the topic of fundamental rights is only catered for by the European Court of Justice. That's why I think that national focus points and national counterparties can have an active role in this, because we can ensure this bottom-up interaction. To this, training new legal professionals is crucial. And as a focal point, the first thing I did is mapping the situation of universities in Italy. And I used the data from the University and Research Ministry, the Italian University and Research Ministry. And until 2021, 550 university courses which deal with the concrete aspects of the application of the Charter. Well, I saw that there are 550 courses like these, so I think that universities are doing their part. And I think that SELECT project also followed this approach. And I had the opportunity to confirm this by reading the manual. Today's event is further proof of this approach. So we have the European Charter of Fundamental Rights, which we are bound to comply with. So let's try to turn this into an opportunity rather than a risk. Let's try to be open and make sure that we create interdependence between the various national legal systems. Thank you again. That's all from me.
Grazie, grazie.
Thank you, Mina. Thank you, Director. Now the floor is for Professor Tizzano and our speakers. Thank you for being here.
Buongiorno.
Good morning, everyone. First of all, I would like to say hello to every one of you, and let me thank the organizers for this meeting, in particular Miss Bartoloni, that carried out everything regarding the organization of the meeting. The main topic of today's meeting is the Charter of Fundamental Rights of the European Union regarding issues, dilemmas, perspectives. So today's meeting aims to debate the Charter with the most important problems. Of course, it's normal to debate about important topics about the Charter, but furthermore, we have to acknowledge that the Charter is a very important document with a lot of questions and problems. Let me remind you that before being applied like a juridical text, the Charter proposed the declarative character and mandatory character. So we saw during that period different and various answers. Nowadays, we perfectly know the character of the Charter, and for the reason we can notice the importance of the same document. And the Court of Justice emphasized the importance of the document. In fact, reading the judgments of the court, there is no doubt this charter is more important than the treatise, mentioning the principles that were inspiration for the Union. And with these tools, we can interpret the norms and regulations of Union. So it's like a constitutional charter of the Union. According to this point of view, we could notice that it's like the discussion we had regarding the Italian constitution when we spoke about the ordinary regulations. So using several judgments, the Court of Justice consolidate this charter, strengthening the fundamental rights and showing the problem of the charter and of the law of the Union. For the reason we have today a very challenging and interesting charter. Speaking about the effects of the charter, we ask ourselves some questions. For example, the values of the charter, the importance of the final articles, like mentioned, like Professor Bartoloni mentioned, the effects on legal and national legal systems, and the correlation. So a lot of topics that can be very useful to contribute to our debates. And I think that these aspects will be very interesting today when we will have the possibility to speak and to talk with our speakers. So please, according to the order of the program, Mr. Roberto Bin, full professor of constitutional law at the University of Ferrara, who will talk about multiple protection of fundamental rights and its deceptions. So please, we are in the center of the critical analysis. Please, Mr. Bean, the floor is yours. And sorry, please, just 20 minutes each. Otherwise, we could face some problem of time. Thank you. You know that prudence is not my best virtue, but you know, today I'm not going to talk about Charter of Fundamental Rights regarding the effectiveness of this Charter, because I'm very worried about the experience of Charter of Fundamental Rights in our country, in Italy. For the reason I speak about the mistakes and deceptions of a particular interpretation of Charter of Fundamental Rights, because according to my opinion, as Eugenia said, there is a trend by Court of Justice that wants to abandon a particular way of behavior, because if we had a possibility to write again the Charter, maybe we would write it in a different way, because you could have a lower, with more prudence, with a different strategy. So what's the problem of Charter of Fundamental Rights in the Italian legal system? We can notice two mistakes. The first one is that the principle of equality expresses a right. But this principle, in particular, the negative point of view, doesn't represent a right. Rights are principles. And these principles, as 𝗖𝗿̈ci said, want to reach the highest level of implementation. So the principle of equality has nothing to do with this right. And reading the cases of courts of justice, thinking that they are writing about the rights of the Charter is not right, because this case of law is brought by principles made by directives. So, for example, think about the labor rights that was proposed by the Court of Justice, and we can see a direct effect. And for the reason, speaking to judges, they decided to, of course, you perfectly remember that we were talking about the discrimination. And in this case of law, regulations that refer to Charter of Fundamental Rights regarding labor and discrimination rights are just an added value. On the other side, we can apply this principle in a broader way. You can, of course, you understand that the prohibition can't be applied directly. Of course, can be horizontally applied. It's so typical that the Court of Constitution, in a 1937 judgment, wrote about discrimination against the woman. You remember that was dismissed for gender reasons, and the Constitutional Court said that the prohibition of discrimination can be applied in the entire legal system and is made to exist in an horizontal way. So according to this point of view, we acknowledge that the problem has to be considered in a proper way. So please, let's remind that I'm not worried about the effects on the I mean, the problem is with the problem, how it affects the case of law, and this brings us to another problem: the multi-level of rights. So we should be worried not about Charter of Rights, but about rights. We should understand what does it mean, right? We have a vision of rights that is very famous for the several courts of acquisition that can't be managed, because rights is imagined like a box, and every protection is divided according to the right box. For example, the first box, the second one, and so on. For the reason, we could think that every box can be increased, and according to this theory, the multi-level theory, the philosophy that dominates the application of rights is the highest standard. As Marta is here, I don't want to speak about the recent impacts on a case of law, but this theory of the highest standard is totally wrong. Rights can be mentioned one by one. With the so-called mystic vision that can be observed sometimes. For example, with Ferraioli, with absolute rights. There is no absolute right. We can find them in the national system. Joseph wrote an introduction in 2002 for an Italian book that is perfect, of 𝗖𝗿𝘁𝗁𝗿, not so mentioned, unfortunately. And he underlined this problem, the problem of balance of rights, because rights are created in a conflict. The conflict of rights is very typical. 𝗪𝗿𝗁𝗿 wrote a perfect text about it of the 70s and translated by the Jewish community of Marco Goldoni, but it's not well known by Italian doctrine. So it's a very good point of inspiration for the creation of rights in the society. Because if we have a problem, of course, two parties wants to be the right one. So removing the rights and the administration of rights in the conflicts of rights, looking for a balance, is a mistake. As Violet perfectly wrote in this introduction, with a balance, among rights, I mean always, the most important thing is not the enunciation of rights, but the balance, the point of balancing. That's the fundamental point. That's what the Constitutional Court said finally, because this point of balance, this balance became fundamental. From this point of view, the theory of multi-level and high standard protection of rights has an eschatological vision that doesn't represent the reality. So studying the protections and the several documents, we can ensure the highest level of rights. Yeah, but we have to consider that if we consolidate a right, we have to notice that other rights are in conflicts with this, with the first one. So if we know that a balance exists between the different rights, we can consolidate just one of them. So it's impressive that this philosophical vision was adopted by case of law, and we could talk about judges, important judges and important courts that adopted this vision, thinking that even the national judge has to work on the protection of rights. So looking for the protection tries to consolidate just one right on an highest level. So the Charter of Fundamental Rights has to be adopted and mentioned with prudency. But the domestic case of law has no prudency a lot of time. Because if a judge tries to consolidate just one right, he's not a judge anymore. That's something that we could miss sometimes. What's different between a judge and other collaborators of public administration, as both of them have to work with impartiality. The judge has no interest, has no personal interest, like an administrator of a public worker. So the only interest of a judge is the application of a right. That's what we can learn from manuals and books. Well, so if it's true, if the judge wants to be the Ministry of Rights, he can't be a judge at the same time. And we can notice this particular phenomena in the Court of Justice, because if the problem of the Court of Justice is to increase the rights, the European rights, it starts to work like a public worker, not like a judge. So there are several theories that can be very dangerous theories. This vision of civil case of law is the result of a political vision that was born during a meeting that was about alternative use of rights. But this type of rights say that judges have to interpret the law underlying the Constitution. So that has to be the interpretation of right. But however, the multi-level rights doesn't carry out this function. It doesn't serve a function in advantage for countries. In order to use this right, you have to pay a good judges, and it's an important cost. So that's like party for rights. Yeah, more rights for everyone, good rules, but that's not possible. And the result is more rights for richest people. The other problem of the Charter of Rights is the domination of Court of Justice of this Charter that is traditionally regulated by the four principles. These are not the rights, but just one type of rights, according to what constitutional charter of our countries contribute with the social interest. So these research of highest standards brings a result that's not the result the founders wanted. Removing the power of the social market and of the, I don't know if Joseph maybe remember these things you wrote about. Thank you for your attention.
Thank you, Professor Bin. Probably the reason he doesn't remember all of them because there's too many of them. Thank you for your very insightful presentation, and I broadly share your point of view. I'm not sure whether the Charter dominates the court or it's the other way around, because the Charter, just as the constitutional Charter of Italy, for example, is a set of principles that need to be assessed in practice. And so the interpretation by courts is even more crucial in the case of the Charter than in ordinary cases. So also, when you mention the prohibition of discrimination, which is based on directives and not on the Charter, well, I think that it actually, and this is confirmed by the court, it is grounded on the directives. It is, yes, but because the Charter exists, that's why it is grounded on the directive, because it is actually grounded on the Charter. So, of course, the directive would not have be directly applicable if it wasn't based on a principle, which in this case is the Charter, or in other cases it might be the treaty. But I think you opened some interesting perspectives, and also critical perspectives, so to say. Now, I'll give the floor to Professor Cannizzaro, who will talk about the intensity of protection of European Charter of Fundamental Rights. Mr. Cannizzaro, you have the floor. Thank you, Chairman. First of all, a personal note. I feel humbled every time I talk about law in front of masters of law, very high-profile scholars as you are. And today I feel all the more humbled because of some personal reasons. I didn't have the time to fully prepare my presentation, so I'm sorry if it will be like bits and pieces here and there missing. But I hope that I will get the message across. Now, in terms of intensity of the rights enshrined by the Charter, so there is something akin to a standard of the Charter. So how does the court define the intensity of rights? Well, I think something I can hunch from the case law of the court, I will share it with you today. There is an issue of intensity, and there will always be an issue in terms of intensity, but this is it's exacerbated by the fact that we have a plurality of protection instruments. If we only had one, for example, if it was only about what the court says, be it the Constitutional Court, the European Court of Human Rights, well, that would define the intensity. But since we have a plurality of protection instruments, well, we probably have a problem with abundance in this case. If we go back to the early 80s, constitutional courts were calling for a catalogue of fundamental rights at EU level. Well, we now do have one, but now we also see the issues that it brings about. So the point is that we need to define a method to make sure that the various rights can coexist. And we are talking about rights which in theory, have the same content. For example, if we think about formal law, and as it was interpreted by most courts, well, you see that at least formally, the content is quite similar, but there are differences. These were already mentioned in the introductory speech. So there are discrepancies between the interpretation of courts as far as the content of a single right is concerned, and as far as the intensity of a single right, individual right, is concerned. So the court does not provide a standard for protection. It doesn't provide an intensity level. It simply provides some mild coordination versus other instruments of protection, for example, the European Convention and the national constitutions. We have a reference in Article 52, paragraph 3 to the European Convention, which sets out the minimum standard applied by the Charter, as opposed to the standard envisaged by the Convention. And on this, I totally agree with Professor Bin that the broad protection criterion has some technical limitations, but also cultural limitations. And more on this later, because rights are not an abstract notion, but they are actually applied and implemented, and the way they are implemented is affected by the setting of a state, both legal setting, cultural setting, and so on. So from this point of view, the broader protection perspective is a matter of style, and but technically speaking, it also faces some significant obstacles. And then let's go to Article 53, which refers both catalogues, that is the Constitution and the Convention, as having the power to establish a higher standard. And we know well that the European Court of Justice is not really keen on this higher standard that is set by national constitutions or by the Convention, because it would create fragmentation within European law. And this was stated in its opinion 213, and it's also confirmed by some opinions which were issued in the 80s and in the 90s, where the court set a limit to the applicability of the Convention. So what defines the intensity of a right? Well, I draw this from Mr. Bini's presentation. It depends on the limitations of a right. There can be explicit limitations that can be provided for example, by Articles 8 to 11 of the European Convention, which prove that a right cannot be absolute. No right can be absolute. So limitations on the one hand. And there is an interesting trend with the European Court of Justice, which has become sharper or more intense in the last few years. A few decades ago, a research by 𝗪𝗿𝗏 showed that the references of the European Court of Justice are not so much aiming at coming or setting a higher standard, but rather at identifying the limits of rights, the limitations of rights. So in an early stage of case law at the European Court of Justice would invoke the European Court of Justice would be invoked to set the limits of individual rights, rather than to analyze their contents. I myself carried out a partial research over the last few years, and I saw that in 2022, I saw 29 direct citations and direct references to the European Court of Justice, and there are also some indirect citations and references. But I think that's a good sample to begin with. And in those instances, the court refers to the European Court, but only in a few number of those it does so to refer to limits. So this reference to limits is a rhetorical one, because the message here is that if the European Court of Human Rights states that a certain right is limited by a certain circumstance, then the court, the national court, feels authorized to subscribe to that interpretation. And so there are other instances which we're short of time. I will not go into all of them, but 36 cases, 36 instances, for example, in 2021 of judgments which refer to the limits. So for the rest, individual courts have been increasingly relying on the case law of the European Court of Justice, of Human Rights. And sometimes they do so by direct reference to the judgments of that court. For example, when it comes to the notion of law, the Court of Justice had to define the limits to Article 8, freedom of thought. And it is said that according to the European Court, law is not a formal law, and therefore it equates a decision by the President of the Parliament to a law. And I think that is a tricky way of joining the two types of law, of the two types of case law. But apart from the limits, I think there is a number of other topics that affect intensity. Topics are set out in sentences which vaguely summarize the content of those rights. And based on that content, all the other sentences and all the other elements of an individual sentence are important. And I would like to give you some example to clarify this. When we talk about assets in protocol number 1. So we need to qualify assets. And assets have been qualified by the European Court and also by the European Court of Justice, but also by the National Constitutional Court. And the way that it has been qualified is not the same across these various institutions. There is a judgment by the Court of Justice, which was issued last year, according to which assets based on UK law, the definition of asset was based on case law, on the European case law. And so another concept, the notion of domicile. This is also highly controversial, and has been debated ever since the 80s. So how do you define domicile? When you do define a domicile, you can make the right to privacy more or less intense. And there is also a very famous instance of criminal sanctions, and I will give you more on this later. But also there is also the issue of contractual obligations, which is included in Article 1 of Protocol 4. So how can you provide a unique interpretation for that notion, the notion of contractual obligation, when you have so many different legal systems? And finally, and I'm saying this bitterly, the notion of torture. A judgment issued last year by the Court of Justice, the court rightly found that also on the basis of a reference to the European Court of Human Rights, the repatriation of a third-party citizen who could not be provided with sufficient medical treatment in that member state is not equivalent to torture, but rather to inhuman and degrading treatment. And I think they took that from the case law of the European Court. So I would like to draw an analogy between this very broad notion, which perhaps a few years ago was even broader than it is now, and the notion of torture as provided for by Italian law. So in order for there to be torture in Italy, the act of torture needs to be repeated multiple times. And so it is a matter of how we qualify the notion, whether it is from a legal point of view or from a social point of view, and who is in charge of qualifying those notions, who is competent to do that. Well, in the case of torture, the lawmaker took care of it. But other than that, it would be the court. But which court? When you have a catalog, a transnational catalog or a national catalog, or you have national and international courts, which of them is competent? So this brings us to an issue which has no easy solutions. Maria Eugenia was talking about harmonization earlier, and I agree, even though not necessarily on harmonization as a technique, as a method for interpretation, but rather on harmonization as a way in which the court determines the intensity of a right on the basis of the European law and on the basis of national legal systems. But harmonization is itself a very broad word. It has been interpreted differently by the courts, by the court itself. In the case of Meloni, it was about harmonizing a parameter. Maria Eugenia mentioned a couple of examples in which harmonization was involved the subject matter, and specifically the notions that need to be interpreted in order to determine the content of a right. So, in that case, it was the issue of when a law becomes statute barred. So, there is no law for that. But when you qualify a notion like that, then you can understand the intensity of protection of the principle of rule of law. So, from this perspective, already we see that there are several interpretations of harmonization, but there can also be implicit harmonization, non-formal harmonization. And I think the Court of Justice is beginning to explore this and its implications, which might overlap or might be close to another notion that we were familiar with, that is the discretionary margin, which is broad when there is no uniformity of rights and of legal culture and of social habits between the various states, and which becomes narrower when there is, on the contrary, a shared view on those points, on those aspects. So I see that informal harmonization is being referred to, for example, in the very interesting case of ritual slaughtering, in which the court balanced, so to speak, two rights. But it were not really two rights, because on the one hand you have freedom of religion, and on the other hand you have the rights of animals, which are not exactly human rights by definition. And I'm a vegetarian, so I know something about it. It is very hard to qualify them as human rights. So in that incident, it was about a crucial principle enshrined by the treaties, which does not qualify as a human right. And so what the European Court, that's something the European Court couldn't have done, because the European Court doesn't have its own fundamental principles. But the Court of Justice, in the case of slaughtering, of ritual slaughtering, emphasized the importance of the environmental and animal-friendly concerns that can have an impact on setting a threshold, and also on setting a limit to freedom of religion. And I think the court was very cautious, but in its ruling it was also very convincing, because it found that that was a formal limit which was acceptable from not only from a medical point of view, but also from those who practice ritual slaughtering. So, in terms of substantial harmonization, discretionary margin, and so on, there is one topic which was very much talked about in the past few years, and it has to do with the intensity of a right and its the relation between rights and the legal and social settings. And I'm talking about the notion of criminal sanctions. And we've seen that the court hasn't been consistent throughout the years because of the judgments A and judgment B. And we can see that there is a changing intensity, which goes hand in hand with with changing standards. I'm referring to the opinion of the general advocate of a general advocate, in which the issue was to find out what happens if the standard of protection provided for by the European Court of Human Rights changes and is not maximized, but it rather goes down, it decreases. So in that case, it is a matter of finding out whether the implicit criterion that you shouldn't go beyond the protection standard set by the European Court or below that standard, even though recent case law says that in some cases you might actually cross that line. But anyway, if that principle no longer applies, the point is, does that principle no longer apply if the standard is lowered? Well, the court didn't have a theoretical approach to this, but this is my view. I think it lowered that standard, and based on other arguments. And of course, there is the courts have a very broad set of instruments to do so. But again, the European Court changed the intensity of protection, and it did so referring to the notion of criminal sanction. You might remember the EGM case, which dealt with a confiscation, and the European Court, by applying the notion of criminal sanction, lowered even further the standard. And this, I mean, it has been amended by European judges as well. Well, basically the standard was lowered because member states were very concerned that by broadening the notion of a criminal sanction, you would undermine some very well-established national traditions. So the court lowered that standard significantly. So here it is about if qualification, or whether qualification should impact the determination of the intensity of right. And I think that the solution that Maria Eugenia put forward might be adopted, or at least studied. And if we are talking about harmonization, then we need to talk about a convergence of national legal systems. And this seems to have been confirmed by recent European Court of Justice case law. Thank you.
Grazie, Professor Canizzaro.
Thank you, Mr. Canizzaro. I think that, of course, we have to have a reference, a substantial reference to, speaking about harmonization. Because the courts and judges have tools, very impressive tools, as Mr. Canizzaro said, in order to manage the situation and manage the interpretation of regulations applied to concrete situations. On the other side, we have to remember that we are speaking about hundreds of judgments every year with different levels, different cases. So creating a consistency of interpretation of the interpretation is not so easy, but of course we can see an evolution, an improvement, especially for the European Court of Rights. You're right, they didn't worked on this before, because of course they had no good relations before, and it was not necessary. But nowadays we can see a good atmosphere, and we have the desire to use the judgments of European courts to improve the Court of Justice, so we can notice more references. I would say a constant reference. Same thing about courts and judgments. Of course, they can provide with an impulse. For example, what Professor Bit quoted, obiter dictum. Yeah, it's right. It's not mandatory, but we worked on this principle for many days because we wanted to insert a message, and this message was elaborated word by word. So it really was a great work carried out by people who wanted to improve this message and people who didn't want to. So our job and the job of judges is a very complicated and difficult job, because through the time we have to update the same judgment or the case. Before, the interpretation of this judgment was according to us well-centered, well interpreted. So thank you. And now I would like to give the floor to Professor Weiler, that is going to talk about the problem of the standards of fundamental rights. Thank you, the President. I've not been speaking Italian for many years. Please be patient, bear with me. Preparing my conference, I tried to count how many times during the last 30 years, 45 years, I participated in a conference about fundamental rights, and Strasbourg and constitutional courts. And the structural problem didn't change. It was the same 40 years ago. And the first thing I would like to share with you, we can see the same problem according to a political point of view. In the 79, there was a proposal for the applicants of the Charter of Fundamental Rights. It was obvious because the European Union proposed to 9 member states the adoption of this charter. So how can it be possible that the European Union is not the member? This was an obvious proposal, and it was very interesting that the Court of Justice organized a hearing, and after 40 years, we know this very famous decision. Someone says that it was a very well-prepared decision, well organized, but I don't think so. It's a matter of politics, because a lot of bodies, parliament and so on, said, okay, we agree, but I have a suspect. I think that it was like a game. I mean, we want to be right, we want to say the truth, our truth about the rights and European rights. This is my suspect, but we have to admit that Roberto Bean was right. Do you know what changed during the last 40, 45 years? We have a lot of popular rights, and people say more. If we have more rights, is better. If we have more protection, our society will be better. And it's true, we have more rights, especially against discrimination. And the protection of fundamental rights can be, this improvement can be made in a positive society, but we have to pay two prices for this improvement. The first one is a common price. Sometimes the Court of Justice or Constitutional Court, if they decided to consider something like a fundamental right, there is no political debate, because it's considered like a fundamental right, and that's not matter of democratic state of rule. We are not talking about torture, but let's think, for example, about social debate where the society is divided. We are not speaking just about the empowerment of the court, because saying that this is a constitutional right, there is no political debate, because the Constitution decided it. So this is something we have to pay. It's like the economic inflation. The more rights, the better we live. And I would like to work with Mr. Bin to demonstrate why I agree with him. So, yeah, of course, we said, and you, Mr. Bin, said that if we increase the level, of course, we can reach new and better rights. For example, abortion. Of course, abortion is the highest level of rights for the abortion, is to give more freedom to the woman. And if we consider the protection of fetus, the highest level of protection is the one that gives freedom to the fetus. For example, we can consider Denmark and Poland. They have different levels of protection, but both of them offer freedom. Or, for example, religion freedom. Of course, Catholic Church gives a lot of work in this case, because if I want to protect the rights, the labor rights of a woman, I have to respect this principle, but at the same time, maybe I could protect the woman or the religion, the point of view of the church. So which kind of standard we have to protect more? We can't say it. Or, for example, the freedom of expression. But if we consider human dignity, there are some kind of expression that damage the humanity. So, according a philosophical point of view, it's very difficult to decide what do we prefer, fetus or woman. it's very difficult to speak about the highest level. But of course, you could say this is an exception because the fundamental rights are part of individual and political power, and of course, it gives more value. Let's see it together.
No, bisogna di
Hai messo in crisi.
Io sono obiettore di coscienza a PowerPoint.
C'è da scrivere?
Si vede?
Can you say it?
Mettiamo qui Italia.
Let's write Italy. That's just an hypothesis. And Germany. Let's think about the protection of private property. The introduction is more protection. The more we protect, the better we live. Is this true? I don't think so. For example, in Germany, protection of private property is higher than the level we have in Italy. Gods are against me. It doesn't work. So, for example, the first one is the level of Germany, and the second is the Italian one. So the highest is the German one. So we can expropriate, paying, but the opportunities are more in Germany. So someone could say that the Italian citizen is not so well protected. Let's consider two cities, Munich and Florence. In the city, we can, both of them, we have two houses with garden and no public parks. So the municipality decided to expropriate the house to transform it in a public park. In Germany, they can't do it. In Italy, they can. Because the protection of private property is not so high. So which society would you choose? That's what my colleague said. Who said that the added value belongs to the highest protection? In this case, for example, between Germany and Italy, because fundamental rights, as my colleague said, depends on a balance between fundamental right and collective right. So why should we prefer the rights and not the society? If we say that European protection is better than Italian one, maybe the Court of Malta doesn't agree.
Il livello italiano era più alto della Germania, ma dal punto di vista valoriale non è parola giusta.
Because of course, we can consider the economic factor, but what about values? Maybe, considering the values, maybe is better to have not the same level of protection in order to enjoy a common good. And how can we manage this dilemma? There's the introduction, like for example, the Article 53 says, because it says that we have to involve more member states to offer a highest level of protection, individual protection, but I think that you can see this admiration. So that's not always true, because sometimes our lowest protection reflects the value that represents us. So who said that individual right has to prevail against the common right? I would like to finish with a comment about harmonization, because according to someone, we should find a way to harmonize. Everything has to be consistent and perfect together. But sometimes not having harmonization can be productive. Let's think about the US having several standards and different criteria can create a very good balance between the individual and the common right. So this attempt to find a good harmonization maybe doesn't give us the possibility to improve. So thank you for your attention.
Thank you, Joseph. You always surprise us. With your presentations, in terms of both form and substance and content. Is that a compliment or is it a critique? Well, first of all, it's a fact. And you always surprise us. But we always try to be a bit confrontational, you know, when we have these events. So we're used to it. But this time around, I can't really object to anything you said, other than, apart from one point, which is not about your presentation, but rather is on the judgment of the European Court of Human Rights, which I myself drafted. And so that's a personal issue. So it's been 10 years since that judgment. And neither the Commission nor the Member States have found a way to overcome it, to do better than that judgment. So they've met every year to address the objections raised by the court, but they haven't been successful. But it seems that we are now close to a semblance of a solution. But anyway, And I'm not so sure that because somebody wants to have the last word, but anyway, we're united in diversity, yes. But other than that, I totally share your points and in terms of the broad spectrum of solutions that we're dealing with. So there is no better result really that can be defined in terms of individual states or parties or anything. So with that, I think we have come to the end of first round of very interesting presentations, very insightful presentations. And so there is diversity, but there's also some common ground here. And so let's hear what Mrs. Marta Cartabia has to say to wrap this up, to wrap today's event up. So I think we can give the floor to Mrs. Cartabia for some takeaway messages. I can use Joseph's microphone, perhaps. Okay, so I think, first of all, I'd like to thank you for your invitation and for the opportunity to talk about these very important topics, which I have devoted a lot of years to as a scholar and also as part of the court. And of course, these are recurring themes. The last couple of years, I did something else, so I probably missed some of the latest crucial developments, which might have helped solve the dilemmas, which was something that I devoted so many years as a judge and as a scholar, but I still see that we haven't really solved those. So thank you again, Professor Bartolozzi, for organizing today's event, and it was a very fruitful debate. And I would also like to thank you for your excellent training work of honorary judges select. And I would like to say something about those judges, because I think this program is really important. I have dealt with honorary judges as the Minister for Justice in Italy, and I had to safeguard the fundamental rights of honorary judges because we had some issues in terms of labor right protection related to honorary judges here in Italy. And on that occasion, I realized that they are very important. They're an important pillar because we have nearly 4,700 honorary judges in Italy, and we have 9,000 ordinary judges as part of the Italian judiciary. So we're talking about nearly 2/3 of the whole number of judges in Italy. So it is crucial that they are at the forefront of implementing European rights and the rights of individuals. This is obvious. So let's go more into detail about the multi-level protection issues. So the last time I dealt with this issue as a member of the government, I was attending the European Council. It was a few months ago, and we were talking about the European Convention on Human Rights and the adherence of the EU to that convention. So there seemed to be a move towards that, but we still haven't seen the outcome of it. And that's because pluralism and plurality of that we have been talking about, and that Mr. Canizzara was mentioning earlier, also has to do with the European Convention on Human Rights and the work of the Court of Strasbourg. So when I was listening to your presentation, one thing came to my mind. It's actually a question. Is it true that the problem of relationship between national systems and the EU law have also surfaced when it comes to Strasbourg. But yes, that is true. But I think that nowadays we have a more orderly approach, or at least we have reduced conflicts with the Court of Strasbourg in terms of the frictions that can still be observed in the relationship between national legal systems and the Court of Justice on the topic of the protection of fundamental rights. So there are differences of approaches between national courts and the Court of Strasbourg, and they exist. But it seems to me that they have been sort of attenuated by the appreciation margin notion, which clarified the roles in a way. It doesn't mean that we reach the same outcomes on the same cases. There are still different views. Cannizzaro mentioned the matière pénale and criminal sanctions, but all in all, this notion of margin of appreciation enables us to have a standard, a common standard, even though there is margin for each individual court to, on certain aspects, to have discretionary power. It's not always easy. For example, let's talk about the notion of margin of appreciation, of discretionary power, when it does not help to solve the controversies. And I was thinking to myself when I was listening to the presentations earlier, and I was wondering why it is more challenging in the setting of the EU to find a balance between the relations. And one answer might be, and it's something that we need to take into account, is that the European Convention of Human Rights does not have an issue which the Court of Luxembourg does have, that is ensuring consistent application of the EU law across member states. It does not have the problem of ensuring that directives that deal, for example, with non-discrimination or with certain regulations are uniformly applied across member states. That's why the extent to which national legal systems have been harmonized by EU law is relevant. Because if we have to guarantee, to ensure and safeguard the EU law in all member states, then we have a shorter, a smaller scope for discretion. For the rest, in its relations with member states, the EU, when it comes to fundamental rights, seems to still be faced with two recurring problems which have not been addressed yet in a definitive way. First of all, the direct application of the Charter and fundamental rights, with all the caveats which were mentioned by Professor Bin, and which I think is something that all member states at one point have had to deal with. But in Italy, specifically, more specifically, and perhaps we try not to focus too much on this, because much of this problem, of this issue, has to do with the structure of the Italian Constitutional Court. And why am I saying this? Because if we say that the Charter of Fundamental Rights is directly enforceable by law, by ordinary courts, the result of that is, well, therefore you don't need to appeal to the Constitutional Court. So why do we have this dilemma in Italy? Well, because you have two ways. You can have you can also appeal to the Constitutional Court in Italy. So the judge is faced with a dilemma. So in this case, they sometimes will have to refer to the Constitutional Court. But when there is an action that is brought directly by the citizen, well, that issue does not apply, because a citizen has the power to appeal the Constitutional Court in Italy as well. So it was relevant to talk about this in Italy, because of this specific characteristic of the courts, of the Italian courts. And I'm not sure if this applies, or to what extent it applies in other member states. For example, I discussed this with my counterparts in Germany, and they do not have this kind of issue. The other topic, which has also been discussed and mentioned earlier, it is the topic of the level of protection, maximum protection level, as enshrined in Article 53. And this is something Professor Bain and Professor 𝗬𝗓𝗏 touched upon, but also Professor Cannizzaro himself, when he talked about limits. So there are limits to law, to rights, and so he made a number of very effective examples. And we have, for example, in Italy, you mentioned private property, and which is you took it as a given that it is a fundamental right. But here in Italy, our case law has evolved in a different way, because there have been some limitations that have been attached to it in Italy. So I think that is the issue, the cultural issue which underlies the broader issue of protecting fundamental rights. And in the EU setting, which is what we're dealing with, this is relevant, but it's also relevant at the national level. Mr. 𝗬𝗏 was saying earlier that we have turned, when certain concerns have been turned into fundamental rights, we are in fact separating the powers. On the one hand, we have the lawmaker. On the other hand, we have a court. At a European level, well, that adds on to the various interpretation of national courts. So on this, I would like to mention a study that we worked on when I was at the Constitutional Court, and I think part of that is really relevant, and this is very specific to Italy, and it deals with one of the decisions on the 𝗖𝗿𝗏 steelworks case. We have this huge steelworks plant in Taranto, which is a very important area for the sector for the Italian economy, and also is a major employer there and elsewhere. So this is also, on the other hand, it is a very polluting activity. It brings about huge environmental and occupational health problems. In 2013 and in the following years, the Italian Constitutional Court was asked to decide whether the regulations that apply to 𝗖𝗿𝗏, to this steelworks company, were consistent with protection of fundamental rights. So the question that the court needed to address there was, which fundamental rights are we talking about? Because the regulation applicable to that kind of activity implied a number of requirements in terms of protecting, for example, the freedom of business or the rights of workers, but also a number of environmental concerns, health concerns, and how to protect the lives of workers and of the citizens of that area. So it was really tough and complicated decision to make. You cannot really establish what maximum protection is there. We have a tradition, constitutional tradition here in Italy. Some of the main scholars here, Paolo Barilli, argued that the criteria should be expanding liberties as far as possible. But in this case, the expansion of liberty does not really clash with the power of the state, but rather with the rights of individuals, which are also guaranteed by the Constitution. So in that judgment, I think there is a passage there which I think really synthesizes this, and it is, I will quote, and I think it really clarifies a lot. This is a very specific, as I said earlier, it's a very specific case for it. So all fundamental rights protected by the Constitution are always in a mutual integration relationship between them. So it is not possible to identify a single right which should prevail over the others. So protecting rights must always be systemic and not fragmented in a number of norms which are not coordinated and are potentially conflicting. Because otherwise you would have an unlimited expansion of an individual, a single right, which would become like a tyrant and would be have an undue prevalence against other situations and other cases that are also protected by the law and are also an expression of the dignity of individuals. So I think that is a very important point, because it talks about tyranny. So, but it applies that concept to individual rights, so to single rights. So if a single right prevails and does not take into account the other requirements, which are also related to individual rights, then that right becomes a paradox. It becomes like a tyranny for others. So only if we see all rights together, then we can express the protection of dignity of humans. So this applies at a national level, and it has to do with constitutional protection, but it applies even more so. There is a multiplier effect at a supranational level, where the diversity of legal systems, united in diversity, is exacerbated in a way. So should we just give up? Should we simply accept that this conflict is going to be there without attempting to create some order and to bring together these conflicting instances? Well, Mario Mazzatti, when he mentioned Europe, often referred to a place of orderly pluralism. Well, there is a unity in plurality, and that is true, but we also need order. So how do we make that happen? Article 51 gives us a formal criterion, and it talks about competencies, but the notion of competence can, at its core, be very clear, but it also has a lot of gray area around it. So I'm not saying that is not useful, that criterion is not useful, because the whole Charter of Fundamental Rights was created to bridge the gap in terms of protection at a national level. So historically, the origin of Article 51 is clear, but it's not enough. Article 53, concerning the maximum protection, is not very helpful for the reason I just mentioned. So what else can we do? And I'd like to, and this is something that I actually learned from Professor Weiler, and I would like to share with you lots of years ago, many years ago. And I have the privilege to see that it has now been embraced by the Italian Constitutional Court. And it is this: we need to accompany formal rules which aim at creating order in pluralism with rules about relationships. So Mr. Weiler is right. There are conflicts, and these conflicts are not only a matter of regulations, but also a matter of interpretation. So balancing is crucial, but competence is also important. We need to understand whether it is for the lawmakers or for the courts to assess this, and also from a substantial point of view. And this applies to the European courts as well. So I'd like to mention here two approaches that were taken over the last few years by the Italian Constitutional Court, which are not so much focusing on formal competence-related rules, but rather on how to create a relationship between the various institutions. One is the Taricco case, which there were several competencies from several competent courts, and so that was deferred to the Constitutional Court. So because the idea there is that we need to have a debate, and we need to make sure that each needs and each requirements are represented. Likewise, the same approach was followed by the court with the Italian lawmaker on the 𝗪𝗏𝗏𝗏 case and on the defamation and later on the life sentence cases. Well, there are some constitutional sides to those laws, so there was a need to strike a balance. And this was not exactly within the remit of the court. So what the court did is it experimented with a new approach, which is based on Canadian case law, but also in German case law. So it gave a timeline to the lawmaker within. So it let the lawmaker find a way to address the constitutional problem that was attached to those laws within a time limit. So far, if we try to take stock of it, well, we cannot be too enthusiastic about the results, because on several occasions, the lawmakers did not really address the issue of constitutionality. So when courts leave it to the lawmaker, they get criticized because it's seen as some intrusion in the political realm by the court. So there were a number of reasons why the lawmakers did not make the most of that opportunity. And in that specific case, a law by decree was adopted, and so the issue was solved that way. But on top of apart from this, or from individual instances, what I think we can take away from this is that there is a need for order. Lack of order, disorder, is not good for our system, for our national systems. But it cannot simply be a geometrical order. A more geometrical order. So when we talk about multi-level protection and relationship between the various legal systems, Ideally, we would like to have some clear guidelines. So this is for the court to decide. This is within the remit of the national courts and so on. So we'd like to have these clear guidelines and a bit like if you had a charter, when you had all these different lines. But I don't think we will ever have that kind of a charter, that kind of model within our system, and we shouldn't even want something like that to happen, because otherwise we would create like a cage rather than allowing a society to develop. And I think this has to do with the relations between the courts and political decision makers. We're also talking about we're actually talking about a Pollock model. So we have lines that cross, the crossing lines. So we have common points. And I think that when we are striving for some kind of order, then we have to create channels that can connect the various dots. And I think that is important because it helps the development of the individual. But at the same time, it does not create fragmentation, and it does not create conflict, unsolvable conflict between the various parties. But thank you. Okay, so I think with Professor Cartabio's wise words, we can wrap up today's event, and I think it was a very positive discussion. We found a common ground despite diversity, which can enable us to overcome the problems, and hopefully future developments will help us overcome this very challenging situation, these very challenging conflicts. So having a dialogue between courts is important. There was a similar case to the Taricco case in the 80s, and there was the advocate of state, Mr. Ferri. This dealt with a judgment by the Court of Justice, which was unconstitutional, and the court eventually changed its judgment, and the case was solved. But that was as a result of dialogue. So dialogue is important, is crucial, because it helps us adapt situation with the changing society. So I would like to thank all the rapporteurs, and would like to thank Professor Cartabia for her conclusion, and thank all of you for attending today's meeting.
Chiaramente siete tutti invitati ad un light lunch o pranzo, come preferite, che è stato predisposto da queste parti, non so bene, ma sentirò l'organizzazione. Grazie ancora per essere stati qui.
Ok, ho alto il volume, va controllato, sì, poi dopo basta spingere. Buon pomeriggio a tutti.
Good afternoon, everyone.
Vieni, vieni. Sì. Ok. Allora, intanto grazie per la...
Thank you for waiting. I know that someone is listening to us through internet, so thank you for listening. I'm 𝗂𝗏𝗏𝗿𝗏𝗍 of FB European Consulting, one of the partners of Select project. As you know, this morning we had the opportunity to experience a very important conference talking about the Charter of Fundamental Rights. And so right now I'm going to speak Italian, but don't worry because you will listen to the translation. So wonderful. I was saying that after this wonderful project and after these 2 years, this 2-year project, we had the possibility to exchange our opinion, and this was proposed by Professor Bartoloni of University Barvitelli, and she was right because it was very interesting. But now we are going to talk about our project. This experience was a 2-year experience, and it was a very good introduction for the time we are living in, because after the presentation in the Council of Europe, they underlined the necessity to train lay judges and justice operators in the framework of the Charter of Fundamental Rights. So they repeat the necessity to establish the right of the Charter. So I'm going to manage the intervention. So I would like to give the floor to Nina. She's going to introduce herself. She's the representative of the lead partner of the project. Please, I would like to discover the work you have carried out. Thank you. Good afternoon, everyone. I'm Nina 𝗖𝗍𝗶. I'm a PhD of European rights, and I worked in the framework of the project Select in my university. As Mr. 𝗏𝗏𝗍𝗶 said, I represent the work carried out by Università Valvitelli with Maria Eugenia Bartoloni, that with Giulia Dagnone, Rosita Silvestre, in the last part of the experience with Angela Festa. Representing my university, I'm going to present the different stages of the project very briefly, considering the time we have. So, as we have seen during the first part of the day, the project aimed to train this particular target, lay and honorary judges, to understand the proper application of the Charter of Fundamental Rights. 2 years ago, Margherita Morelli considered the possibility to introduce and to understand this field of application. Why did we choose the Charter of Fundamental Rights? Because it's very important to understand the law of the Union and of our countries. So the scientific team wrote a manual to offer to justice operators, a very useful book to work on jurisdictional activities. But how did we get and how did we understand the topic of the manual? We used a questionnaire, and the objective of the questionnaire was, first of all, understand the first target of the group. Secondly, we had to understand the charter and the activities linked to this charter, and researching the knowledge regarding the procedural rights to find out if it could create a conflict between the topics. So after finding out the results, we wrote the manual. The manual, called Charter of Fundamental Rights in the Legal Systems of the European Union, was published in our website, and you can, it's freely downloaded. We wrote the first part explaining the sources of the law of the European Union, with a very detailed part regarding the application of the Charter and the lack of application of the Charter. A central part of the manual was written thinking about the rights of the Charter, especially in our activity. For example, the criminal law, minor protection, and so on. And the last part of the manual was dedicated to other tools that can be used by judges in case of conflicts. So when there is need to propose the case to court, especially in the Court of Justice, the findings were the main topic of training courses. We organized 9 courses in e-learning with a theoretical content. This type of course let us involve a lot of participants, especially with the material that we share with our colleagues. And the last part of the course was the practical one, where our colleagues had the possibility to apply what they discovered during the courses in a practical way. After the formation, we wrote a methodological text, and we cooperated with Vanitelli and other colleagues in order to share the guidelines to propose the same formation, the SELECT project, to other countries that were not involved in the formation. Scientific materials had a conclusion with the exchange of best practices between trainers and students. And as you can read in the report, for example, the D4.2 report, what we have seen we discovered that the participation there was represented by a high level of interest, and judges admitted that they started to apply the charter with more responsibility in a conscious way. So what can we say? In our legal system, of course, the European law affects our countries, so the best practices have to be accepted by the justice operators. And this is the hypothesis we can propose after this event. So we are very proud of the results we got. And let me conclude with a few words, because I would like to thank every one of you, those who participated in this project. Thanks to the Professor Bartolone, the scientific team, our partners, and the 𝗖𝗿𝘁𝗶𝗿 Pace National Association. Thank you. Thank you, Nina, Mrs. Faiola. Thank you for your kind words. So I would like to continue. Before giving the floor to Mr. Ryanair, I would like to emphasize that this project was very important, as Mrs. Faiola said. We are talking about 1,733 judges that received this formation in Europe. That's not just a number, that's a need that we noticed in our continent. So we got the result thanks to the effort and the commitment of our partnership. So thanks to the partner of our partner group. Sorry, I forgot to underline this very important aspect, that it was a 5-partner project. So, of course, the idea came from our lead partner, the University of Vanvitelli, but of course we have to we have to thank the National Association of 𝗖𝗿𝘁𝗶𝗿 Pace for the effort, and thank the WENC, thanks to FB, thanks to the Consortium, to Union Européenne des Magistrats. So, thank you. Please, Ms. Ryanair, I would like you to tell us your experience as you are representing our European partners. So, can you tell us about your experience and the impact for the judges? So, please, the floor is yours. Thank you, Mr. Ryanair.
Welcome, everybody, especially the hardcore team who heard the bell waking you up from the siesta. The others are still sleeping, apparently. My name is 𝗖𝗿𝘁𝗄𝗿 from Vienna, and I have the honor to present you the experience of the non-Italian part of this very famous SELECT project, representing the countries Germany, Belgium, France, and Austria. So not only the so-called German-speaking countries, but in the last phase we included even France. We learned to know this morning a lot of theoretical things and theoretical aspects of the chart, and I will try my best to give you some experience how the part north of the Alps anticipated this project. And the first question was, what by hell is the Chart of Human Rights of the European Union? And when we studied the questionnaire, quite clear, nobody told, I have no idea. But most of them answered, perhaps I heard something from it, but what is inside? And the first important thing we learned in this project is that the function of lay and honorary judges in the different countries are quite different. So the project, which was initiated by the University Vanvitelli, quite clear, focused on the fact of the pieces, judges of the peace in Italy, but north of the Alps, in fact, this function do exist only in England and in Scotland. A little bit it was in France, a little bit it is in Switzerland, which is not part of the European Union, but outside of north of the Alps, we have no justice of the peace. All this work is done by professional judges. And in a main way, you can have north of the Alps two types of lay judges, the real lay judges, which are mainly working in the field of penal litigations, geschworene, Schöffen in German words. And you have the expert judges, which are, let's say, the honorary judges, which are experts in different fields, which are normally not paid, so honorary, and which are helping more or less professional judges to do their work, but as judges, not as experts. There is one exception in France. The commercial courts in the first instance are handled only by honorary judges and not by professionals. And when you take this into account, you have to see as a result that the importance of legislations or charts like what we're discussing in the select is a different approach. So the first impression when we could read the draft of the 180 pages manual, so what by hell is this, who should read it? And the result of this 2 years work is that we have to adapt the knowledge of legal text like the chart to what the judges really need in their daily work. And this is, for instance, in the judges of the peace in Italy, quite different than I take as other extreme, the lay judges in penal matters in Austria. We have in Austria a system where you are elected by some list, you be a citizen, and then you get a letter for the next 2 years, you are theoretically a lay judge. Most of them never are called, and when they are called, they get from the ministry a 40 pages handbook, what is their work. 90% of the lay judges who are coming to the litigation handling, they even did not read the 40 pages. And so their interest in learning law is in fact zero. It is a little bit different with the expert judges, because first they are experts and secondary, normally they are much more interested in legal details and so. And when we have the idea to expand some type of select project within Europe, the most important message is we have first to look what is our target group. And when the target group are, for instance, in some countries, only lay judges in penal matters, we have to analyze before what are they doing there, what is their role, and then adapt the transfer of knowledge to their need, to avoid that people are saying, why by hell I should read it. We had in Austria a very interesting info day not as foreseen in the project that we motivate 50 lay judges to participate, because this we did automatically, but we invited the representatives of the Ministry of Justice, of the High Penal Court, of the Commercial Court of Vienna, of the Chamber of Commerce and the Chamber of Labor, which are nominating the expert judges for work disputes and so on, and presented the select. To be very honest, everybody told, yes, okay, if it's necessary, we will support you. But if we looked into reality, everybody told us we have no time, or we are not sure that our colleagues or our lay judges will listen, and so on and so on. They avoided to say no, but the mentality, especially in the ministry, was, yes, it could be interesting that somebody knows of the chart, but unfortunately, the next 3 years, I'm overcharged with my daily work. I cannot issue some scriptum or so. Okay. Only to give you an impression how it runs in reality. And nevertheless, we succeeded in Austria to have a very interesting, nearly 1 day presentation by a university teacher of Salzburg, who presented us a chart from his point of view, which was in fact the same content like the manual. I'm sure he did not read it before, because he knew what is inside, or most of it. He made his own schema, but in fact, I compared, it was nearly the same thing. We had very interesting presentations on, this was physical, very good. We had a presentation online in Germany in 4 or 5 evenings, with every time nearly 1,000 interested people. There was only one limit of the online system per evening, which were mainly expert judges in agriculture matter and in some administrative matter, way of honorary expert judges, which is very common in Germany, but nearly not in Austria, for instance, to compare the countries. We had an interesting evening physical in Belgium during a session they had there, and this was working very, very well. And even the workshops afterwards showed the experience we should have, and I will not go too much into details. It is clear that physical presence is much better than online. If it is online, it has to be very efficient and not too long, to avoid that people are sleeping, because you can do it only end of the day, and end of the day, the energy to listen some theoretical thematics is not so easy. And quite clear, you have to interrupt it, you have to give possibility for questions, and so all the know-how everybody who has made seminars has. And I repeat, the most important thing which we learned is, if you tell the people that the chart is existing, they are more or less interested, not too much into details, but we have to focus what is really interesting for them for their daily work. We made in the workshop in Austria, I made a questionnaire with 54 articles. What, in your opinion, and I showed them the text again, what is the experience, what do you need, what do you think is important for you? And it was exactly what they suppose from the title could be interesting, for instance, for expert judges in commercial matters in Austria. So nothing with asyl, nothing with children, nothing with marriage and so on, because this is not our target. And when we want to expand to Europe, important thing is analyze before what is the target group, what are they doing, and what are they needing as juridical knowledge to better do their job. To finalize, it was a very important project, thanks to the European Commission, thanks to 𝗲𝗏𝗏 University and Eugenia, who was the boss. Unfortunately, we had due to the COVID not the chance to see each other every month like foreseen. And a very special thank to Mrs. Margherita Morelli, who is the real founder of this idea and the most energyful person within all this European group of lay and honorary judges. Thank you.
Thank you, Rainer. Thank you for sharing this information and for your very honest and accurate analysis of your work. So I'd like to give the floor to Mrs. Roberta Desai, who is the chairman of the National Association of Justices of the Peace. And then I would also like to ask Margherita to join us here on stage. But Roberta, I would like you to share your experience with this project, for your association. What did it mean for it? Thank you. Well, I will be, most of my speech will be about thanking those who contributed, and then I will leave the floor to Margherita, who will go into more detail about how we carried out and how it all played out. So we arrived at the final stage of a project which has been truly inspiring for all of us. Not only those of us who work behind the scenes, who are organizing the work, but also target group, our target group counterparts who we have discussed a lot with in order to gain a broader understanding of how it all applies in the daily work. I must say this was a truly amazing, this has been a truly amazing project. We're all excited about it, and I hope that we were able to convey some of this enthusiasm to our colleagues. As an association, we are really proud of having been a part of this project, along with the university and our European colleagues from the OMEC Consilium and FB European Consulting, our partners from FB European Consulting, who have provided technical support throughout. So I would also like to thank Professor Bartoloni and her staff collaborators, co-workers, and so on, who drafted the manual, which will, I'm sure, be very valuable for us, and also for arranging various training activities. I would also like to thank our European partners, whom are represented today by our friend Rainer, and all the engineers of, technical engineers of FB, who have provided technical and also support us with all red tape issues. I would also like to thank Francesca Ranossi for her valuable work in liaising with institutional counterparts. So she's done a great job. I would also like to thank Research Center in the person of Margherita and Gabriele. So it has been teamwork, really, and we are all pleased with the outcome. In terms of the impact of the project, well, I'll leave that to Margherita. Again, I would like to thank all of you for participating in these training activities. So also those of you who are joining us remotely today, thank you. So I'd like to give the floor to Margherita. Margherita, please join us. So Margherita, tell us something about your experience with the project. Well, looks like there's only a few of us left. Well, no, there's many actually are attending online. So, okay, we'll finally have the opportunity to meet in person here, at least, because so far we've only really met online. So, 2 points. We did a project with elementary school pupils, and we took away this from that: the love for Europe as a homeland has been fruitful. And I must say, unfortunately, some people no longer love Europe as they did in the past. But still, we work to make sure that Europe becomes more and more popular. Nothing happens by chance. And each work entails a lot of efforts and a lot of human relationships. As Italians, we're good at establishing relationships, especially us, I must say, from Naples. People from Naples are good at that. We have a sense of friendship. Perhaps we're a bit theatrical sometimes, but this opens a lot of doors. Sometimes people can tell that we are honest. And even though I must say this is sometimes just our way to exercise anxiety. I'm glad to have our guests here today. For example, Mr. Reiner, who has been very supportive. And I must say there were some misunderstandings with the Pole and with the Polish partners. But thanks to Reiner and Paulette, they've traveled across Europe to find people and colleagues who would be interested in participating in this project. I am very close to Paulette, who has helped me out throughout this European journey. So I would really like to thank Reiner for the amazing work. He's a great man and he has been very supportive. I tried to support him, but I really owe a lot to him. And he's very patient, I must say. And well, this started quite a few years ago. Nobody really believed in this when we signed the European Charter of the Lay Judge. But I must say, I have always been supported by two amazing people, Roberta Tesei and 𝗪𝗶𝗍𝗍. And so when you are supported by people like that, then you create a strong bond which cannot be dissolved. And we have worked together at on the European side of the Lay Judge. I remember this was really a last-minute project that I took on. We were sent a notice by the Court of Appeal, and we're talking about 2008. So this was a EU-funded project. But I must say that ever since then, there has been a lot of support from these two people that I mentioned, and also lots of Tunisian students, Moroccan students have been able to join and to be trained. And I must say, Mektid Bauman has done an amazing job in supporting our European project. So we drafted this European Charter, which was signed by 20 European countries. And I must say that it acknowledged part of our code of ethics. And we, as Italians, have contributed a lot, because we contributed part of our Code of Ethics, which is itself based on the Code of Ethics of professional judges. We share the same duties with those judges, even though we may not have the same rights. So this was actually reflected in Article 8 of the Charter, and this was the first chart that ever to create some common principles for all European lay judges. Then, and with a lot of effort, we organized lectures, talks, conferences, and we created the European Network of Lay Judges, which was set up in Berlin. And I must say that our German counterparts are very good at this. They have this strong desire for Europe, which perhaps is not as strong here in Italy. But from then, a statute was drafted, and it laid the foundations for the principles that should guide European initiative in this field. And we also shared our experience with the Swedish counterparts. We submitted our findings to Mrs. Wikström, and we also shared many of our papers with them, and also our challenges. There was a declaration which was drafted in Stockholm, another one was drafted in Belfast. Well, perhaps our European colleagues may not understand all of this, because we're talking about lay judges who and in many cases, we're talking about expert judges. So they not necessarily address specific legal matters. But all in all, this has been a 12 years effort. And I have myself published articles, papers, and stories about this on the websites, and I also took part in several fora. Unfortunately, I wasn't unable to attend the last one in Portland, but I must say that because unfortunately I was injured, but I must say that my daughter, who speaks English, has been very supportive. She attended all the meetings with me, and she would translate hundreds of documents. So she was, so to speak, our official translator for all these events. We also held a number of congresses in Rome to discuss with European judges. We also created a link to the translations of various documents. So there has been a consistent liaising with our European partners, and we have created some very solid human bonds, and we've fallen in love with Europe because we have met people like Mrs. Seddenmeyer, like Mrs. Paulette. So these are amazing people who have ensured that this project was successful. So we have built a lot of human relationships, and it was thanks to those that we were able to share ideas and to identify the principles that we needed to address, especially when we're talking about union law. We have worked with counterparts who address different topics, but they decide and they agree to study the Charter of Fundamental Rights in order to interact. And I must say that we have also been able to apply these rights in actual life. So it has been an interesting exchange. So my message is that human relationships are crucial to any project. Individualism should never prevail. Teamwork, on the contrary, should prevail. Sometimes you may not share the same views, but I must say those who have worked in this project have done an amazing job. Federico, Francesca Borzi, the red tape expert, and she allowed us to make sense of lots of reports, invoices, and administrative documents that we had no idea about. So we also had an amazing accountant, Gabriele Di Girolamo. I'm not very good with figures, so I contributed passion and commitment. And I also laced with the education, with the word of education, with some teachers in order to understand how to disseminate the importance of the Charter in schools. But we also try to involve a political world and the world of politicians. And we also try to arrange a number of workshops and info days. Well, I must say that those who contributed have always done a great job, and they brought the experience that they acquired as part of these training activities into their daily work. We also worked on the social media. We, through, for example, Messenger, through Instagram, we created a European group. So it was a lot of hard work, also online. And we involved the Court of Appeal and so on. But it has been really rewarding because we saw that there was a lot of interest from the institutions, and I was surprised because I didn't think that, for example, we would get so much support from the education world. But we saw lots of high schools who sponsored our training activities, and that is important because it means that there is some awareness in schools as well. And this can strengthen our position because, yes, we do need unions, but we also need value. We also need a way forward. So I'm sorry Professor Cartabia isn't with us right now, but I shared with her a lot of material and documents, and she told us about her experience as a lecturer, and I hope that she will at least check out some of the documents that I submitted to her. We have been asking her to do so for a long time, and perhaps if she had been more supportive early on, then perhaps her reform that was carried out, that she proposed, would have been more effective. But anyway, as I said, it's been a lot of hard work, a lot of effort, and I hope I was able to convey at least part of my passion. So I thank you again, and I hope the future will be even more successful for myself and for all the honorary judges involved. Thank you, Margaret. Thanks a lot. Thank you very much, Margherita Morelli. Well, we should call you Professor Morelli, even though we are actually friends. But your passion has really engaged all of us. As you said, the SELECT project has been long in the making. It was started many years ago, and it is not only about fundamental rights, but also about creating a support network of people who can enhance the instruments that the European Union provides to us. And I would also like to mention my colleague Gabriele, who always keeps a low profile. So Gabriele, well, Margherita, we're going to run out of time. But I'd really like to thank Gabriele because he did an amazing work for the accounting side of it. Yes, projects are made of people, and I think that the work of all partners have been really high quality. So we're close to the conclusions, so I'd like to thank all of you. But before we take some questions, including online, I would like to give the floor to our project manager, Eugenia Bartoloni. You like the mic? So Professor Bartoloni. 5 member states involved here. So there you have your mic. 732 judges attending info days, 73.5 training hours, 1,732 judges trained throughout Europe, 16 events, 2 important outputs, such as the pamphlet and the manual, 24 months of work as part of the project, an impressive amount of views. So these are really impressive numbers, and which testify to the importance of the work that we carried out. Yes, indeed. I might not say anything new here, but would like to, first of all, thank you all. And I really should thank all of you. And Mr. Sedermeyer, who is the only foreign partner who attended today's event. So thank you wholeheartedly for being here. And I would also like to thank our broad range of partners, starting from Andrea, first and foremost. Everything started from him, from his enthusiasm in designing a European project. So it all started from Andrea and from FB. I will not forget any names, don't worry. So, but it was all started by Andrea and FB, European Consulting, and of course, the partnership was a result of those initiatives. So, of course, we had the contribution from Margherita Morelli and the Association of National Judges, Roberta, and all the other partners, not least the Vanvitelli group. So we're talking about very talented researchers who took it on themselves to do all the work. And I must say that they took care of all the hard work. So what I did is I simply supervised it, but they really did the hard work. So really, thank you all so much for this experience, which isn't over yet. As Federico said, we're talking about amazing, massive numbers here, because we have achieved a lot. But why not carry on? We don't know yet how. We don't know yet what the way forward is. But of course, we can start from going into detail about certain aspects of the Charter that haven't really been investigated yet, or focusing on other areas of EU law. But we will definitely not leave SELECT without any future outcomes. We will make sure that something is delivered in the future and that we will be working on future projects. So, apart from the numbers, SELECT has highlighted a number of important points. The category of honorary judges is a diverse one. But despite this diversity of skills, which can range enormously between member states, they are a solid category. They're resilient. I like the adjective, resilient. And Margherita indeed confirmed that this category is resilient. Often overlooked, it's an often overlooked category, but it is crucial in the administration of justice. There are, as I said, lots of professionals, different skills, but we will try to follow up on this project. Thank you again for being here. I would also like to thank those who are attending from home and all the honorary and lay judges who have believed in us and who have been consistently following our events. Thank you all very much. Again, without you, we wouldn't be successful. Thank you. Thank you, Professor Bartoloni. Well, I should also like to thank two crucial professionals, besides Carlotta and Eleonora and Andrea, who supported this project. And I think that's it. Unless you have questions, whether from the floor or online. Do you have any questions? We are not receiving any questions. So that's it. I would like to thank you all again and congratulations. And I would also like to thank the European Commission for making it all happen. Thank you again, and have a nice rest of the day. Thank you.